closing schedule, so we're just full-time Uber drivers.
I would like to call this meeting of the Anchorage Election Commission to order. Today is October 25th, 2023, and the time is 2:03 p.m. Madam Clerk, would you please call the roll?
Chair Torkelson,
Present.
Member Treadwell,
Present.
Member Lehman,
Here.
Member Ireland. Ms. Torkelson, you have a quorum.
Thank you. We'll now review the minutes of the previous meeting from April 20th, which should be before you.
Madam Chair, I move approval of the minutes of the April 4th, 2023 public session of Canvas minutes. I'm sorry, the April 20th minutes of our Canvas of the April 4th election.
Okay, do we have a second?
I'll second.
Okay, Chairman, or Mr. Lehman seconds.
You can ask if there's any objection.
If hearing no objection, the motion carries. And we heard no objection, so minutes have been approved.
Madam Chair, for the second set of minutes, I'm not going to make a motion, and maybe this is out of order until somebody does, but I have a question about the minutes when it's appropriate.
Go ahead, Mr.
I'll move the adoption, the approval of the minutes for the meeting of May 1, which I attended.
All right. Any comments? Open up for comment.
We need a second.
Do we need a second? We need a second first. A second. All right, we have a second. Any comments?
Sure. Madam Chair, this is, in my mind, a very good example of the fact that we have minutes that don't say anything. I have no idea what happened at this meeting. I know that there was a lot of discussion at the previous meeting during the canvass. Did we come up with any guidance? Was any informal guidance given to the commission, to the clerk? We had a situation where we had asked the clerk and a complainant to kind of get together on some issues beforehand. Was there a meeting of minds? I'm just wondering if there's any after action on this, because this relates to what we'll be talking about in the meeting. And I did not have time to hear the entire tape.
I think that this May 1st meeting was the after action. The complainant was requesting, at the April 20th meeting, was requesting information. He was doing a public records request for records that we don't create. And so in the April 20th meeting, I had agreed to create the record for him. And so the April 1st meeting was a presentation on how we produce our list. And then it was providing him with a thumb drive of the newly created record that we created for him.
And that was, and through the chair, that was a record of the people who were not put on the list for some reason.
It was the record of the people who were not mailed a ballot, correct?
Okay. Just, again, because I've had one member of the public talk to me about this issue, but because I hadn't been at the meeting, I wasn't aware of where we got on this. Would you say that you and the complainant are now of a general understanding of how it worked, or in his mind, did we still do it wrong, or has this been resolved generally? Because I just want to know, is this a continuing policy issue that we need to worry about?
I believe that the complainant would probably did not get clarity and probably still has questions, but and would like policy changes, but I can't speak. I don't feel comfortable speaking to putting words in their mouth without them being here. I think that there's been information brought to Ethics and Elections Committee meetings and articles written on blogs that make me believe that things still aren't adding up for him, and he would potentially like policy changes, is my understanding.
And not also speaking for him, but having had lots of campaign experience, if you are somebody, say, canvassing to get votes, you obviously want a good list of who's out there, in the old days, who's received absentee ballots, since everybody's getting a mail-out ballot. And so now it's almost the flip side of who might be eligible to vote, who's not getting a mail-out ballot for whatever reason. And, there was obviously a material number of people who didn't get it for, well, you explained were appropriate reasons, but even if the voter for some reason feels it was inappropriate not to get a ballot, that voter has the right to come in and ask for a ballot or vote a question ballot or that sort of thing. And I can see that campaigns would want the transparency of that being available. So I guess the question I have is there a policy that kind of generates that list that we should bring forward, or was that discussed at the meeting so that people could have it? I mean, it's funny. I occasionally look at a directory of a selection of members in an organization, and if somebody hasn't paid his or her dues, they're not on the list anymore, and yet I would go back and say, why don't you reinstate your membership because we need your help, type thing. And I guess what these guys are looking for is something that I would suspect we would be asked again and again. I mean, I might ask for it if I were a candidate. So I'm just wondering what our policy is today.
Our policy today is that we get the entire Anchorage voter file from the state, and if a public records request comes in requesting the entire voter file, it can be sorted as far as UN, LM, and those types of, and all the different condition codes that the state gives us. And so if they did a public records request, which he did, then yes, the campaigns are provided with, whoever asks is provided with a list of the voters. We do not get the ascension numbers, and I know that was another issue. We don't get the ascension numbers with our voter list. They could also go to the state and request, I think they have to pay a fee with the state, but our policy is that if there's a public records request and they ask for the list, they can get the list and sort it and learn who the undeliverables are if they wanted to go door knocking and encourage those people to go vote in person. And yes, those people on the list in list maintenance and undeliverable are registered voters. They can go to the vote center and vote in person. They can call and request a ballot be mailed to them.
Thank you. Madam Chair, I may bring this up in the legislative portion, but thank you for bringing me up to speed on the meeting and that issue. Thanks.
Right, what I recall of the meeting is that I personally didn't really hear something specific that they were asking for. And I recall asking them, is there something specific that you want? And there was no definite or defined change or what have you that came out of that particular meeting. All right, any other comments or questions? And if not, all those in favor say aye.
Aye.
And hearing no objection, the motion carries. So the May 1st meeting's minutes are approved. All right, on to old business. And as far as I understand, there is no old business to discuss. So we will continue down to new business. Madam Clerk, is there any new business to add to the agenda?
I don't think we need to add. I think that the way it's worded will get us through what we are here to talk about today.
Okay. So we'll go on to our topic, which is review of the election code and observer handbook amendments. And Madam Clerk, if you could start the discussion, please.
Thank you. So I admit that I neglected to let Amy know that I don't have the observer handbook amendments available at this time. I will start with the code updates and let you know that, as you may know, the Assembly has been conducting an inquiry into an election complaint that was brought forth in the May 4th election, and ongoing discussion and a report coming forth. Based on that discussion, there may be additional amendments brought for the ordinance and the handbook. And I think Matthew has a few concepts that he can describe after I'm done with my piece. So what I'm going to talk about today is what the staff is recommending. This work has all been done in about August, and then based on reports and findings of fact, there may be additional changes, at which point we will either pull you guys back together in a meeting or have a joint work session with you and the Assembly to figure out the Assembly side of this stuff. So the ordinance and AM are in front of you. The ordinance, if you guys want to look at the ordinance, I will review the AM for you so it explains what's happening. So on page 1, AM 2810-040 definitions, we're adding a definition of voter registration file. There are two separate places in Title 28 that mention a voter registration file, and so our observer liaison, Ralph, suggested adding a definition of voter registration file to provide clarification, and that's on page 1. The next edit, 2880-015, clarifies that the municipal clerk's role is to invite at least one of the specified municipal employees to observe tabulation. AMC 28-100-020, I apologize. 2880-050 and 2890-025 are sections 3 and 4 on pages 2 and 3 of your ordinance, and those are simply citation corrections. There are no substantive changes in those two sections. And then starting on page 3 and ending on page 4, which is section 5 of the ordinance, the election contest procedure. So when first enacted in 1985, the code provisions required election contests be submitted to the Assembly for possible action at the same meeting where the Assembly would vote to certify the election. The code was changed in 2020 to provide that election contests could be submitted within 9 days after the certification of the election. However, it did not provide direction to the Assembly on how to handle contests filed after it had already voted to certify the election. There was no process contemplated or provided for how to uncertify an election. And so, so the change here is to change it back to requiring that a contest be brought to the assembly, again, on the day that the assembly is taking up certification. And we're also adding a requirement to include specific details relating to the contest, so that the assembly has evidence to determine if an investigation is merited, or in what they're, so that they can make a decision in their next steps. So those are the edits that staff, myself actually, and the attorneys have been working on for the Title 28 this year. And then I'm happy to answer any questions on any of that. And if there are no questions, we can, Matthew can give his brief information about what might be coming out of the inquiries.
Is there any discussion or questions by
Yeah,
the
Madam
commissioners?
Chair, can, I guess, first off, and ask Mr. Falsey, are we required, I know that we are, part of our mandate is to give advice to the Assembly on changes to election law. Is there any sort of requirement that if they do something that they work with us or not, or is it just, is this kind of a one-way street?
Through the chair to Commissioner Treadwell. It's an interesting question. It may well be that the code says only that one of your duties is to study and recommend to the Assembly and the municipal clerk proposed ordinances related to an election. I suspect there isn't a code provision that says any change to Title 28 must first come through the Commission before the Assembly can act on it. So I think, to my understanding, the Assembly has generally routed things through the Commission, but I'm not sure there's a formal requirement that it must.
So, Madam Chair, I had communication with Clerk Hines before the meeting. Last, as you recall, in this same contested thing that Matthew's about to talk about, the statement was made, I think, in your very clear defense of our issues of what happens to jump drives, that even if that administrative policy of the city had prevailed, the Assembly had already kind of cut us out from being responsible or to the IT standards of the city, that you had the right to do your own IT standards. I recall that statement. I haven't checked the law. And I guess the one thing I do know for sure is that that was not discussed at this commission while I was on this commission. So I'm wondering, how did that get in the law? Was that the previous clerk suggesting it to the Assembly? Was it without going to this commission? Was it an Assembly member's idea that they needed that? I mean, it just because what we're doing now really didn't happen last year, or at least it didn't happen very well, in my opinion. We weren't noticed as when the Assembly was doing their stuff and so forth. And obviously this is possibly material to a complaint that was before. So I'm just wondering, if you make recommendations, we're making these recommendations that you've drafted for us. Are you making any separate recommendations on your own that you're not bringing before us? And what's the procedure there?
I'm not bringing forth any more changes to the ordinance. But if the Assembly asks, or if the sponsors of the ordinance itself ask, then I mean, our job is to add it to the ordinance. I know I've been in conversations with the chair, and we have a loosely mapped plan forward. This needs to be adopted by the end of December in order so that it is effectively the next election.
Yeah.
And I know that there's intent, because we're only this far in the process, to either get you guys back together to review it again once we are done. I know it's difficult to get you all in the same room together at the same time, and so maybe it's a joint work session with the assembly, potentially in December, when they're between introduction and final authorization. But
Okay.
so we have a
And
loose plan.
You weren't the clerk last year when this was done, but do you have any recollection of how that got into the bill without us talking about it?
I don't know. I have the ordinance here, and I've looked at amendments, and I don't see when what we did do is I have the crosswalk here, which is what I reviewed with you guys at your meeting, which is the majority of the ordinance. I can see that an amendment was made to add section 5 of the ordinance. But I think the piece that you're talking about is 2810.020C, and regarding the election administrator being responsible for the overall administration, including IT and computer equipment. And so I don't know specifically if that was, it's my understanding it was a request of the sponsors.
Okay. I've got some questions or suggestions on the legislation, Madam Chair. I'm happy to hold that until we've heard Matthew's report. Or if you want to move forward with this and then get Matthew's report, I can raise the questions now. You tell me what's best for your meeting.
Maybe listen to Matthew's.
Go with Matthew first and then, okay. All right, we'll go with Matthew's report and then we can hear your suggestions.
Thank you, Madam Chair. Matthew Hurt, Legislative Counsel with the Assembly. Sorry. So based off of the inquiry thus far done by the Assembly, there are two main findings, or at least events that occurred that merit some addressing prior to the next election. The first of which is there seems to have been a disconnect between the stated intent and the relief sought by the complainants in the last election and the mechanism available and the relief available under the mechanism of the complaint process. Previously, the complainants raised issues that they saw as being problematic. However, their stated intent was not to change the result of the election, and there seems to have been an inconsistency with the complaint process and the available relief under that, as it essentially requires an allegation of a illegal election practice sufficient to change the result of the election. And so we've identified that there's a need to clarify and delineate the processes by which those types of allegations are raised and brought before the appropriate body, and when there is a general recommendation or a observed deficiency in the process that really does not raise an allegation of illegal conduct or something sufficient to change the outcome of an election. Those changes we anticipate probably being largely addressed through materials outside the code, like the Election Observers Handbook, the forms available to elections observers, things like that. Additionally, there seems to be a need to codify more clearly the prohibitions on municipal employees participating in partisan or political activities or diverting municipal resources towards partisan or political activities. While this prohibition is largely captured in the ethics code, there are issues with enforceability and the clarity of who it applies to that we think it would be potentially beneficial to maybe address in code, making that prohibition more clear and placing it somewhere outside the ethics code. So that's largely what we're looking at as a result of the inquiry. And I'm happy to take any questions based off of that.
We'll open it to discussion if there is any. Questions?
Yeah, Madam Chair.
Go ahead.
Matthew, thanks for your report, if it's okay to address him directly. On the disconnect between the complaint and the relief is, if you listen to the transcript of the meeting, I led some of the questioning where I said, okay, what are you trying to do here? Are you trying to overturn the election? Are you trying to make sure our numbers are right? Or are you trying to just make sure this commission, which also, kind of learns about election procedures while we do this canvassing, there's maybe something that ought to be fixed. And to my viewpoint, it doesn't really matter which one of the three it is. I'll just put it this way. If I'm a candidate and I got 2% fewer than, I came in third or second, and I've done both, as well as coming first. But the point being is that even my standing in another election depends on an accurate vote count. So if I've got a question about the vote count, even if it's not going to change ultimately the winner of the election, I think it's important that somebody be able to bring to us something saying, hey, you probably should have not rejected these ballots, or you probably should have made sure the mail got through, or something like that. It doesn't bother me. Frankly, it doesn't bother me that somebody comes in and says a mail-out ballot, violates his personal and civil and religious rights. That's kind of what we're here for, is to be a sounding board on how the election is working. I think it's we will get, when we get to the legislation, the question of how do you overturn election, but I don't think we should ground rule out a citizen having at least a first place to raise an issue, given all the time the observers have. Because frankly, what we've used it for is to educate and explain as much as to respond. So that's my feeling. Is it really a burden on us or the public purpose to have somebody raise the kinds of questions? Because I can't think of any one of the questions that have been raised that aren't worth talking about, even if they were based on facts that we had. Imagine, I don't believe there was bad intent on what happened with what the ombudsman said. I understand that there may have been, inside information, but it's quite possible the complainant knew about this pending policy months before, kind of said whatever happened to that policy, and if he published it improperly, that's a problem. But the fact is that somebody might know that somebody's working on a jump drive policy is not, it's not confidential information, doesn't screw up bidding or anything else like that. So I guess the fact that was brought to us, and frankly, I wouldn't have known that the legislation changed if Jamie hadn't, I believe it was you, Jamie, who explained two things. One, hey, this thing just came out this afternoon and it didn't seem to follow the procedure. That was good for us to know. And second, we may not even be bound by those IT requirements anyway, given what the law did last year. And so it doesn't bother me that this came up. We learned from it, and I think if anything, our question has to, or as a policy, we might say, what do you want out of this? Do you want to, I doubt we would have overturned or redone an election based on going back on the Liz Vasquez thing on ballots that weren't delivered. But it's fundamentally a big question if for some reason or other, a lot of people didn't get ballots who were registered to vote. Whether or not it's going to change the election, I think it's important that be raised. So I'm just wondering, what's the public purpose of telling people that they can't raise an issue?
Through the chair to Mr. Treble, I don't, and this nothing's been formally put down yet, but based off of the inquiry thus far, I don't think the intent is to prevent or limit somebody raising that issue. It's more clarifying where that issue, the form in which that issue gets brought forward. Whereas before the complaint procedure, the complaint form in and of itself, like there was a requirement to state how, if this allegation were true, would change the results of an election. I think that's more what we're addressing, in that these things came forward on a form like that, were brought in the form of a complaint, which, under the code is an allegation of an illegal election practice. I think it's more to clarify, not that it be brought in that form, but brought in another form, not to prevent it from being brought at all, I guess, if that makes sense, sir.
Yeah, well, if you're asking for advice as you bring this forward, I think our complaint form ought to say, what do you want us to do with this thing? Okay, and let's take the issue of people that didn't get ballots. Here, a complainant was saying, hey, I couldn't even get the list of who didn't get ballots, so I couldn't see, I couldn't moderate that. We were very careful to try to help him get the list before his ability to ask for an overturn of the election. Bill gave us that advice on what the timing was on that during the meeting. And we said, hey, you can't overturn the election here. We can work with our staff to help you get the information. If you feel you've got a complaint, that's where you take your complaint, down the hall, without being bureaucratic about it. But it does, and frankly, if you were to put up any kind of bounds that say you can't do this, that was even a two-part, where he was saying, I can't get the information to make a complaint. Can you guys help us? Which we did. And Jamie did, I presume. And I did read one column that said he didn't like how fast the hell it was or something. But I think you did what you had agreed to do before this commission. So at any rate, it doesn't bother me. And if there's right now the change that is proposed in the statute in the charter doesn't really talk about the process to change the result of the election either. I mean, it just says you got to file your complaint by a certain time. And I think if you have these things come up here, it helps build a record for the assembly to look at later on. So at least my response to you is, yeah, maybe we ought to fix our form, but I don't think we ought to tell people that they can't issue something. And we want these, if you just look what we've done the last few years, we've limited observers. I cannot show up here and even stand in that box unless I've had training, all right? I used to show up at elections counting votes. I have since 1974, okay? Now I've got the city telling me, a citizen, I can't watch a public process happening unless I've had training. I think that's immoral, but we're done, all right? And now—
Can I just correct that? Any member of the public without training can come in and stand in the entryway and walk on the yellow brick road and watch the process.
What's the required training that we have then?
To be an observer, you have to go through training, and the training takes the place of what the state, at the state level, they get their credentials from a party, and the party trains them what to look for. And we are nonpartisan, and so we do a tour and a training to talk about the election process so that they can understand the election process more, so that they can maybe gather an understanding of what they should be looking for as an observer.
Right. And okay, I guess I can say that we're that is in the law and the rules. We have limited the kind of observing. I was wrong in my statement. Thank you for correcting me on that. But I just remember the Hickel-Hammond race in 1978, where all of a sudden we went from needing maybe one observer in a contested Republican primary to needing 100 or or, to basically go watch things. And if there had been a requirement that you can't even come in and observe and represent a candidate unless you've had training, when you didn't even know you needed it before the election, that, in my mind, is an abrogation of the public process. But I'll just leave that behind. I'm not trying to fix that today. What I am trying to say is, let's try not to ratchet things down. That's all I'm saying. In terms of the prohibitions on partisan political activity, I believe if, in all the ethics training that I've had, if you give somebody inside information or and don't give it to the public, you're possibly in an ethics situation. So, I mean, you can answer a question to me. That's probably going to come up the week after, the assembly meeting the week after next. But if you told me the assembly is considering a wholesale rewrite of, zoning standards, but hasn't told anybody yet, you might be violating ethics.
I might make the attorneys cringe here, but I can really talk to you about the forms and the intent of the observers. So in the thumb drive situation, through the inquiry, I think we learned that it wasn't the intent of the observers to attempt to overturn the outcome of the election, but the form that to bring it to you guys specifically states what section of the code do you believe was, not followed in order to overturn the outcome of the election. And so what I wrote down from what you said is maybe our form should better state what do you want, what is your desired outcome, and then bring it to you. And we also have to manage as well. We have a finite amount of time. We have to adjourn by midnight. And so we can't have 40 people here trying to get your attention as well. So, but yeah, again, that was, I think, what we heard.
Thank you. Thank you for your report. Yeah.
All right, thank you. Any other questions, concerns, comments?
I'll just comment that at that meeting, when I heard that it was municipal, I think it was IT policy that flash drives would be scanned, I thought, oh, that makes sense. I'm surprised that hasn't always been done. I would want that done for anything I insert in my computers, and the municipality ought to do things like that. Now, in terms of when that happened and who made the decision and what process was followed and whether that information went to everybody, I never thought about that at the time because it wasn't my concern. I just thought, is it good policy to do that? And my answer is yes. I hope that it is municipal policy. If it takes a process to go through to enact that, do it. And do everything else that we need to do to protect the integrity of our data, protect against, there are a lot of bad people in this world who are attacking and trying to get in. And I know we have people who are very talented fighting them off all the time. And I'd say do your best to make that happen. And not you personally, but tell the folks that do and encourage them to keep doing that. Yeah. Thanks.
Madam Chair, to Commissioner Lehman's point and Matthew, to you, I think that is one question that you might want to consider in the Assembly's inquiry was when what seems to be also a fairly straightforward statement, elections handles their own IT, I'm not sure it was written with the intent to escape from municipal-wide standards, which are, generally pretty good. I mean, some people looked at it, I think the aspersion was made that, aha, this was a way to get out from under the mayor. I don't think that's what you were trying to do. I think it was just saying, you guys got to go do your own specs on very specialized equipment and that sort of thing. But be that as it may, there is confusion between whether or not a citywide, I mean, the Assembly has passed a law that says this, the mayor shall have control over IT generally, then can set standards, and there's all sorts of things in terms of software consistency and anti-hacking and all that. And was it the Assembly's intent to exempt the Division of Elections or the clerk's office from that? And I doubt it was, or at least if it was, I'm not sure it's a very good policy. If it's some sort of tug of war between who controls what, I'd suggest you take that tug of war some other place, in terms of having decent, consistent municipal policy on IT. And it doesn't mean you can't choose your IT. I just think that's one of the questions that came up with us, is whether or not that policy was legitimately put forward. The question is does it affect this or not? And obviously we use municipal things on payroll, we use municipal things on paying the lights, all that kind of stuff. So I would just suggest that be part of your inquiry.
Thanks. The one thing that I would say about the policy is that the ombudsman report indicated that it was an internal IT policy, and it was that day that it was asked to be put onto the muni-wide intranet to be maybe construed to be a municipal-wide policy. And so, so I would maybe venture to say no, it wasn't the intent of the Assembly to get entirely out from underneath the IT department. We had requested a cybersecurity audit of the IT department in 2022, and the day before it was canceled, and so we had struggled. We ultimately had federal CISA come in and do an audit for us, and unfortunately I can't get a paper report out of the very secure system of passwords and blood from my thumb. I'm just kidding. It's a very complicated federal system where you need a couple of passwords to get in. I can't get in and actually print out the report, so I only have the report verbally, unfortunately. So I think that is the intent of that. We're still trying to get some IT things accomplished in maybe some tough times.
Well, toward that end, if we're looking for some sort of guidance on the legislation, maybe something that says, after payroll, a pending election gets priority from the city's IT folks, or something along those lines. After payroll and plowing snow. Whatever it is, but and I'm familiar because I'm married to a city employee of lots of IT problems in this municipality, and they're not fun. But if you've got to run an integrity an election, you ought to be able to get the resources you need to do it.
Any other questions, concerns, comments? Go ahead.
Madam Chair, on the draft ordinance that we have, Clerk Hines, you mentioned that voter registration file definition was a suggestion from one of the observers. Does that?
The observer liaison, Ralph, former municipal
Yeah.
assistant attorney.
Is that likely to affect this issue of the policy that you say we have now, which is to allow people to submit a FOIA request or an information request on registered voters who are not getting ballots in the mail?
No, the voter registration file cross-reference, it's mentioned regarding to the signatures. We get the signatures
Right.
from the voter registration file. And so we just wanted to clarify that the voter registration file means the entire voters registration file maintained by the state.
Okay. In terms of your three choices, the ombudsman reports to the assembly, the IT director and the internal auditor report to the mayor. Is that correct?
It's my understanding the auditor reports to both the mayor and the assembly.
Okay.
And so I can't direct them what to do, but I can invite them to come observe.
Okay. And this is an existing statute, and it's just changing the word from invite to
Select. It was select.
Is there an interest in your part in requiring that at least one of them show up?
Yes.
So, because right now from selected, it kind of is a command performance, and invited is a you can turn us down performance. And if this is one of those belts and suspenders that we're looking at to make sure that IT is done properly, do we want it as mandated rather than optional?
From my opinion, yes, I would like for them to be here. The auditor and the ombudsman have been here. Were here last year. So only one has to be here, and they were both here. And so yes, I would like for them to be here. I would also could envision a time when I don't know that we have the ability to hold up an election if somebody can't make it, or if they were out of town, or emergencies arose, or anything like that.
So, I mean, if I'm going to put my name or urge this commission to put its weight behind saying make it permissive rather than constructive, you know, I understand that emergencies can often overrule a law. That's what all the lawsuits are about in Georgia and Pennsylvania on the national elections, you know, whether or not the legislature can go to mail-in balloting during a pandemic, which wasn't really thought of during an election law, right? But in this case, you've got a situation where more and more of our tabulation is done in ways that you can't see it. You can't see somebody slipping a ballot out of their sleeve. You can't see somebody marking a ballot, you know, looking at a ballot that's marked possibly twice. You know, you're counting on the machine to find it. And so you know, the question of do you have an independent look at this is important. And I guess I would say I would argue against this this change, and I'm just wondering where it came from. That's all.
So he's saying shall be present because you have an internal auditor or designee. So if somebody is sick or has to go out of town, they designate. So you've got a provision for a situation where somebody can't make it and we want them to attend, then I agree that inviting them just allows nobody to show up. So if the goal is for somebody to show up, we've already got a provision that with the or designee.
My email to them would be, you know, pursuant to this section of the code, we're inviting you to observe. Please let me know if you or a designee can attend so that I can send you an invite. And I, based on the past practice of the auditor and the ombudsman to attend, I mean, I know that it's the ombudsman, one of the ombudsman's favorite thing to do, so I don't envision that it was going to be a problem. I just know that I can't direct people who are not, who don't report to me.
But isn't that the purpose of the ordinance, is to direct people who you can't? Is the goal to have one of these three entities?
Well, it says it shall be under the supervision of the municipal clerk and at least one of the following shall be invited.
But I read it shall be invited as, if you want to come, come, and if you don't, you don't have to.
Yeah, so,
So shall be present, I would think, or something to that effect. And the or designee allows for the internal auditor, IT director, and municipal ombudsman, who all happen to have out-of-town emergencies that day. They can always
Send a designate.
send somebody else, but at least somebody, some designee from one of these three
Correct.
shall be present and shall,
Yeah.
they're here.
I would agree.
I guess I'm not seeing a problem with the existing language, and I don't think I'm hearing that from you now that we've discussed it. The remaining parts of this, I don't have any particular issues with. This is one where, unless I'm missing something, I just don't see why this one is necessary, this change.
I would agree with that statement too. You're taking it out of, you have to be here, and now we're changing it to, you can come if you want, but you don't have to. But the goal is to have one of these come, so why change it?
And you might use your selection process much the same, which is, I invite you to come, the code, this is what the code says, I invite you to come, and if they say, I can't participate, then that then directs you, or it would cause you then to more ambitiously go after one of the other two.
Designate.
Or the
Or
designee.
both. Yeah, or the designee.
or say, go hire the university IT person and make them your designate or whatever. I mean, you know what I'm saying.
Yeah. Yeah.
The whole purpose here is to protect the public interest. I mean, consider the agony that we've gone through when somebody was fixing, I think it was over there, in 2 elections ago, and even the jump drive question in this election that has caused more front page stories than almost the library. But the point I'm getting at here is that having this third party reviewer is not a bad thing, and requiring it. So I think you're hearing at least 3 of us say maybe you don't need this change.
Thanks.
Madam Chair, on the other, I just have a couple of questions, and I'm glad that the 2 attorneys are here. On the contest procedure, and I'm more familiar with state law than I am with the city law on the standards for overturning an election. It's very, very hard, pretty much anywhere, to overturn an election. I was part of a team that did it for a week before the Supreme Court said, nah, you can't do that in 1978. And I guess the question is, first off, are we subject to state code in this requirement, or even Federal Election Commission code, which sometimes reaches deep into municipal elections? And what we're saying is, I remember we said that night to these people, you can't contest an election until it's been certified, okay? So it doesn't bother me that the situation exists that you have that you might have certification before that, because when I certified elections as lieutenant governor, I told the people who didn't like it, you can't sue me until I certify it, so don't tell me not to certify it. I mean, you know, that's good up in the Supreme Court. But I guess what I'm getting at here is we're saying that you have to contest an election for the assembly as if they are the last resort, and they're not really the last resort, they're the first resort. And then you go to court and say, aha, but they didn't send ballots to these 172,000 people, or whatever the number was, and thus, you know, they held a bad election. The court would probably hold in your favor, but still, the point being is that the idea for a contest is after certification. Now, you know, I know that we like to certify and swear people in the same night and all those kinds of things, but I just want to know, are we being asked to do something here that's inconsistent with state law and with the ways that contests have been set up in the past?
Do you want me to start and you can? So I looked through many other codes. I'll start with the fact that it's my understanding that Title 29 gives municipalities the requirement to create their own election laws. I researched many other jurisdictions, Fairbanks, North Star Borough, I knew the city of Kenai's, Kenai Peninsula Borough, City and Borough of Juneau, and none of the jurisdictions that I saw had a place where you could contest an election after it was certified. They all have the contest come to the governing body at certification. There's a requirement in our code and many of those other codes that they have to exhaust their administrative remedies before the municipality, before they can take it to the Superior Court. So we're taking, the assembly will be given the election commission's report, my report, and then have an election contest. And so then they need specificity in that contest so that they can consider your report and my report in this contest and decide if we need to pause on certification and order an investigation or order some hearings, or if they can certify dismiss the contest and certify the election so that then they can move on to Superior Court if that's the path that they choose to take. That's my understanding of the law.
And I'll jump in to add some of the history here. I think this year's process exposed that we entered a brave new era in about 2020. So the original rule that we had in the municipality since 1985 was that if you want to contest the election, the trigger is this commission's report. And the rule was within 5 days of this commission issuing its report, you have to send your notice of the election contest to the clerk, and that goes to the assembly. And that tees up a meeting for the assembly where they have the contests on one hand and then the commission's report on the other. And they can either choose to hear the contest or not, or to certify the election results. And that was sensible. And then if you didn't like what the assembly did, you sued. In 2001, there was a slight wrinkle where they changed the definition of which meeting it went to, but it was basically the same rule. 5 days after the election commission, get your contest in, get it to the assembly so they have everything in hand before they finalize the election. In 2022, there was a change the assembly made where it now said the trigger is not the commission adopting its report, it's 9 days after certification of the election. And the explanation that came with that change was certification by the assembly is more public and it's a more obvious activity than the election commission's adoption of its report, which is easier to track timelines. But what that set up was this kind of error does not compute moment, which we experienced this year, where the assembly certified the election, sat a brand new majority of new members, then heard an election contest, which they decided didn't need to actually be heard. But had they heard it, it would have really, I think, caused a, what do you do now to the new members if they find this election contest to be meritorious? Do they overturn their own election? Do they de-seat themselves? It seems to make a lot more sense to say, if you're going to complain with an election contest that the assembly is going to consider, get it to the assembly before the assembly finishes its work. And then as soon as the assembly finishes its work, you sue. Then it's in the hands of the courts to blow up the election, reverse the certification if that's what it's ultimately going to take. And in this proposal, the idea was not to actually say 5 days after you submit your report, but rather to say, as long as you get it in at the last possible moment, well, the assembly will get it. So it's noon on the day the assembly is supposed to take up the certification question. And I think that both gets us back to a place where what the assembly is supposed to do with the contest makes some sense. And as Clerk Hines said, so far as she could tell in her research, that was the way all the other municipalities are doing it. You get the contests that the councils or the assemblies hear into these councils or the assemblies before they finish their certification work. But then otherwise, you always have the remedy of going to court if you don't like that way that turned out.
One point, one question. I'm going back to the election contest that I was in, and actually I've been in several on both sides of the winning side, the adjudicating side, and the losing side. In some cases, it's a question of law. The question was whether or not Lisa Murkowski could run a write-in, versus, there were issues about certain signatures and that sort of thing, but still, there were not fact questions that people had to worry about. Then in the Hickel v. Hammond election, there were a lot of facts, and we actually went through an election, got an election certified, went through the recount, or maybe it was a required recount because it was not hard to get a recount because it was 98 votes difference in a pretty big statewide election. And we went through the recount, and then after we had the recount and it was certified, we then did a lawsuit that allowed us to have an audit. And in an election that had a very small margin, we found 270 ballots in a locker in the Mat-Su election office that had never been done because we audited the number of people assigned in versus the number of ballots counted, and it was a big deal. And that wasn't picked up in the recount. It was a really weird situation. And so there was a recount, so there was an art, and that it was probably that particular issue. The Superior Court found that there were 10,000 ballots counted that should not have been counted and ordered a new election. The Supreme Court said it was a crooked election, but you didn't prove it was crooked in anybody's favor and retained the election. But it was a really weird situation, and it was not fun for any side. We're all friends now. But the point being is that for some election contests, you need a fact-gathering time, which is what I was particularly aware of with the issue on the number of people that had not gotten ballots in the election. And so I'm just wondering if that fits this. And the second question is, given whether Mike Pence should have decertified or the House should have decertified a presidential election, does this political body want to be the decertification group? We kind of don't. We're kind of not the decertification group. They're not a certification group. And the question is, we know we can affirmatively, we send forward a canvass report, but we can't really tell if, we might tell you, hey, change the number on this. We think those signatures should have been accepted, and you would change that canvass report. But if somebody came to us and said, that entire box of ballots lost chain of custody because somebody pulled a fire alarm and the firemen were in here and nobody could see with the smoke what they were doing with the ballots, could we not send it forward? I don't think we could not send it forward. But that's what I'm trying to understand, is the process. Because I see what you're trying to do. Obviously, I'm not suggesting there's any be illogical or, I mean, what you put forward is very practical, but I'm not sure that the choice that we're making is the choice we should be making in terms of where you get to be certified, that's all, or contest.
So under the election certification provisions in the code, the assembly, I just have to find it.
What are you looking at?
If the election commissioner or municipal clerk reports an apparent discrepancy in the returns, the assembly may order a recount of the votes in a specific race or contest or for the entire election. The recount shall be conducted immediately by election officials, and then so the assembly has, if the election commission or municipal clerk reports a failure to comply with the provisions of law or illegal election practices, and that such a failure is sufficient to change the outcome of the election, the assembly may exclude the votes cast where such a failure or illegal practice occurred from the total return, or may declare the entire election invalid and order a new election. So I would imagine that in your scenario of a box of ballots having lost a chain of custody, the assembly has the ability, based on your report and my report and an election contest coming forth before them, choose to exclude them or order a new election. Having been through 2 election contests in Haines, it was related to, the first one was related to how we counted the votes. There was a candidate his name was Damon Hoffman, and we did not count ballots for D. Hoffman. His mom's name was Deanna. And so we didn't know who they were voting for. And in Haines' little situation, our code pointed to state law, and so it was contested, and we did an investigation, and the assembly then certified the election, and it went to court, and the court overturned it. And because of that little provision that pointed to state law, it's only governors and lieutenant governors that have to be entirely written in. And so Damon Hoffman was appointed or elected according to the court. The next time it was a chief of police who moved. He retired and moved to Anchorage, and then moved back to Haines. And we certified him and put him on the ballot, and he was elected. And that election was contested by people who didn't think he was qualified because he moved, and we knew that it's the intent to return, and he said he had the intent to return, and so they did an investigation. We got all of his records, his voter registration records. They, said yes, he had the intent to return, and then the courts got it and said, no, actually he changed his voter registration, so he didn't have the intent to return to Haines, so no, he can't be elected. So those were my experiences with contests. Yes, they're messy. Yes, it causes a pause in things, and you could end up having somebody entirely, a person elected for a week or 2 until the courts are finished. They are required to do it quickly, and then somebody comes in, a month later. So I hope that gives a little picture of how they work. By getting all of the information, the assembly can make a full view of their decision, and then choose to pause things and keep these people seated for a little while we do an investigation and get more information, so that you can make an ultimate decision and then let it go before the court if that's the choice.
Madam Chair, just in hearing this, I don't really have an opinion, except that I'm somewhat concerned about the scenario where the assembly gets to certify and then has a vote on whether or not to contest an election. And I think, maybe something you ought to look at is is the same conflict of interest rules that the rest of us have. If you're involved in that election, you can't vote on it. And you can have an entire assembly there. So I mean, I don't know how you do that, but there's a particular interest there that we might point out that is something to be looked at on that process anyway. As far as the timing, I think the language that you've put in there is fine. And the only other question I have is this new oath. The law today says it has to have notarized signatures of the candidate or the qualified voters bringing the contest. And then it asks for an oath that says that it's to the best of the affiant's knowledge. I don't know, I've never heard that word said, so I may mispronounce it. But and I guess the question is, what are the consequences if it's not true to the best of the affiant's knowledge? And is it our intent, are we thinking that people are maybe doing this just to slow things down, or, are we trying to set them up for perjury, or is this just something that makes it expedient, like a lawsuit, or what's the purpose of that?
I don't know if you want to respond to that, Clerk Hines, but I can say partly the answer, which is I think there is a desire to make sure that the complaints are filed in good faith, which we assume all of them are. There is a consequence to an unsworn falsification. So if you were to submit something that you said, to the best of my knowledge, everything I'm saying here is true, and then we find out, actually, no, this was totally in bad faith, you knew this was a lie when you sent it in, that is a crime in Alaska, unsworn falsification and the second degree. I don't think there's any desire to prosecute people, but I think there is a little bit of a desire to say, if you're going to be notarizing these complaints to begin with, we want you to put your signature on the line and say, this is an honest and true complaint. This is what I think is really happening.
Was there any problem that called for this?
That I would have to defer to the clerk about.
I don't know that there was a problem that called for it. I think it was a request made by an assembly member that we put. It is on all of our challenge forms. It has been on all of our challenge forms, and there was a request to put it on all the complaint forms and the contest as well, so that we're consistent across the board.
Madam Chair, I've got no further questions on what's in the document. I only have one other question about what's not in the document, which is on this issue of our policy of making lists available of people who are registered to vote in the state of Alaska, but are not registered to vote, but are not sent ballots. And they may be not sent ballots because the last address was returned. Can you just review that? And I'm just wondering if it makes sense for us to put either something in the law or your policy in guidance on that. To me, if the city of Anchorage is going to take out 5 pages in the newspaper to tell everybody that they haven't paid their taxes and we can take their property away, that's that. Should we publish a notice that says we're taking your right to vote away because you haven't done A, B, and C? And I'm just wondering if the public notice thing makes sense. I'm just trying to figure out, can you explain that issue a little bit more? Because that was something that came up that I wasn't aware of, that there was such a discrepancy between the state law or the state list and the list that you only sent to.
There's no discrepancy between the state law and what we send to. The state maintains the voter registration database and gives it to us, and our laws say that we are not required to send to UN, which is undeliverable, and LM, which is voters are who are in list maintenance. And so we don't send it to them. And so the person requested that we provide a list of the voter registration that we were provided from the state, and I asked for clarification. The clarification came on election day, and so I then provided, I believe, three of the four requested documents, I think a day or two after election day. The fourth item was a list which we do not create. I don't create a list of people that I'm not mailing to. There's a list, and we separate out, we just refine the list or filter the list to remove who we don't have to mail to. I don't create that. So I gave them the entire list and said, you can come up with the number, by filtering it the same way that we do, and that's how you get it. And the number didn't match the numbers that we had given him, and the reason they didn't match is because we have people request temporary ballots, we have people request replacement ballots, we have the list that we gave them that was the people who have received a ballot. There's a catch up and yank process. So we give the print and mail vendor a list of 236,000 voters, and then in like February, and then there's still more refining going on. People are changing their voter registrations and whatever, but we need for the print and mail vendor to get going on their work. And so then we get another list, right at the deadline of when people are supposed to be updating their voter registration, and we give that to the list. And then there's a catch up and yank process where anything that has changed gets yanked, and everything that has been, changed as in there's a new address to mail them to, they yank them, and the catch up is, and so we didn't do the catch up and yank process with the information that we gave to the campaigns. These people were getting ballots. And so we were just trying to get it out there quickly. I've learned from that. We will now do the catch up and yank process so that our numbers match. But that is why he can't make sense of the numbers, and I've tried explaining that.
What is the last day you can get registered to vote before an election?
It's 30 days prior to election day, which is, this year it was March 5th. And then the state has a week to receive the mail. I think most people do it through online, but occasionally there are updates through public assistance venues and also coming by mail, because it can be postmarked.
Voter registration drives and shopping centers or something like
Right, and so we get a third one then, and then we just process that one in-house.
Okay. And when you provide a list to campaigns, is it 3 weeks before the election? Is it? I guess they may ask you 3 months before an election, but they can get an updated list after that deadline. Is that correct?
I can't give them a list until I will give them what I have. In 2023, I gave an initial list based on the first drop that we got. And then I informed that person that there will be, more updated information coming. And so that person requested it again after the last list was given to us. I think everybody else waited until after that last list was given to us. It's like March 10th that we were able to get the last list.
Madam Chair, what I had in mind was just mandating somehow that we put out the good list and the bad list, or the good list and the transition list, or something else like that. But it sounds to me like you're doing this yank and what did you call it?
They call it ketchup and yank.
Ketchup and yank process after you publish the first list. And you have that. I would urge you to look at some sort of public notice process where if John Jones is not getting a ballot, you either publish it publish it online, say John Jones didn't get a ballot because the last time we mailed to that address it was returned. Sally Jones is not getting a ballot because she's under list maintenance and we got a death certificate, but we haven't pulled her off the rolls yet or something like that. Is that a fair thing to do? I mean, is it fair to do what you're doing anyway and mandate a public process? Or mandate a little bit greater transparency?
I would have to check with the state. I don't know that the state would appreciate us publishing voter registration information online. The state manages. We are allowed to use, they're required to give us for our elections the voter information that we need. But we also have to sign pretty strong confidentiality agreements and agreements for the use of the voter data.
Well, we're not asking you to put their birthday or their social security number or any of those identifiers on the line. I guess what I'm saying is this, it's, my mom died and we're still finding out the places where she didn't close bank accounts and the state has taken the money so we can apply for them. And if the states didn't normally put that out there, you wouldn't have it. If there's, when we publish that list of people that haven't paid their taxes, lots of people use that, not just the people who haven't paid their taxes to say, oh my gosh, often friends and relatives, did you know? And if somebody is, if somebody knows the whereabouts of somebody who's still registered to vote but is not getting a ballot in an election, and you make that public, campaigns trying to find voters, would have it and so forth. It just seems to me that having some sort of public mandate makes sense. Now, I don't know if there's anybody in the public here, we have public comment later, but I have heard arguments that people thought that this was not a good issue, and I've heard the complainant, kind of at least scratch my sensibilities of saying, well, maybe this ought to be more public. So I don't think there's a change in the law, Madam Chairman, so I don't want to hold this up any longer, but I would urge you to figure out a way to at least say, here's who's not getting a ballot and why. And at the same time, you release a list, here's the 300,000 voters that we got from the state, here's the 275,000 that we're sending out to, and the reason these 25,000 have been dropped is for A, B, or C. I just think that because that gives a person a chance to remedy it, that's all. They might not have, just again, remember the agony where nobody was accusing you or your predecessor of deliberately screwing up one precinct near Sand Lake or Jewel Lake, to not send ballots to them. But if we had 40 people march through here and say, listen, I'm a registered voter and they could have found me and I pay my taxes and whatever, and they didn't send me a ballot, I think that's a valid issue that we ought to try to at least remedy with public notice ahead of time. So it seems to me that this is more a practice than a law, but I'd urge you to figure out a way and come back to us and just let us know how you do that. That's all.
So I will state that right now we have just this week mailed out postcards to every registered voter in the state. This is, or not the state, the city. This is the address that we have on file for you. Is this correct? So we're going to get a number of them returned to us as undeliverable, and we're going to provide that information to the state.
Right.
They are still registered voters. If they, and we do all kinds of press releases and communication, like 8K2U comes in and talks to us. If a voter hasn't gotten a ballot and we do radio ads. If you have not received a ballot, you can go to a vote center and vote in person. You can call and request a replacement ballot, and those types of things. We also do, through the public records request process, and I don't even make them fill out request forms. I just need to know that they want it. If they want a list, I'll give them the list of the people, of all registered voters, and then they can filter it based on UN and LM, so they can still see who hasn't gotten a ballot and who has gotten a ballot. I don't know that I can publish because we do have people that call and request. So if I publish it on this day, but in the meantime, later they call in and request a replacement ballot or come vote in person or whatever else, then information changes daily, just like the voter registration. So I think that we're doing the best that we can.
Madam Chair, I really have to agree. Thank you.
Just one comment on that. Would a possible remedy be that when somebody has a public information request, requesting a list, the second list or the third list or whatever, that a letter or explanation showing this is from the original list, subtract out the yank and whatever, just so that when they get it, they have kind of a cover letter saying, here's the original number, here's the new number, and this is why the final number is such and such. Rather than more public process that could cause other problems, but those people who are requesting the list seem to be the ones having the issue with numbers not matching up. But if there was some sort of progression shown in a letter form, a cover letter, here's the information, but no, this is why these numbers don't match up or add up the way you think they should add up.
I can talk with the staff and see if that is a possibility. Again, it's going to start changing daily as these people start requesting replacement ballots or go vote in person instead of having it be on the list.
Do you have, if somebody does a public records request, is that list generated on that day that they requested so that it could be different than the person that requested it the day before?
No.
Or do you have?
There's a daily voted list so that they can see who has already voted. Mm-hmm. And there is the list that we've gotten from the state. It's 3 different lists because it's the whole voter registration, and then we run a process to figure out where the changes happened in order to create the catch-up and yank. So, like, somebody's address gets changed from 1862 28th Street, number B, to number B, 1862 28th Street. That's a change. That's a catch-up and yank. Mm-hmm. Their address didn't change. It just changed the way it looks.
But
and
do you know, how many catch-up and yanks that you did that would somehow come up with these new numbers that people have contested earlier this year?
That's what we gave him. That's what we tried to give him.
Right, but just a cover letter saying A minus B plus catch-up and yank equals this number, and this is why this number and this number don't match up.
I'll have to check with staff and see if it's a thing that we can do once so that we don't have to update the letter every day.
Right. Just a thought.
Thanks.
That makes sense.
Madam Chair, to your line of questioning, and thank you for the time on this. I don't know if it's changing the handbook again or teaching observers that sort of thing. you appear to be very responsive to campaigns. I frankly, when I was lieutenant governor, I didn't always have election officials who were as responsive to campaigns as I think you are. And I'm not disparaging anybody, it was just issues that we had to work on. And if a campaign knows something's going to be a close election, they're going to try to harvest every vote possible, and it's not our job to get that ready. It's our job to provide that information. And so it appears to me that you're doing that. I think the chairman's suggestion of avoiding kind of a sense that people were unjustifiably not sent ballots is there. And it does, I would urge you to look at some sort of a way to, and this may be something you need to talk about with the current lieutenant governor and director of elections, is see if there's a way to say, okay, here is the valid voting list for this election, and here are the ones who are not getting ballots for these reasons. And the other numbers will change as people call in or as people come in and vote a question ballot or whatever. So anyway, thanks for paying attention to this issue. I know that the complainant in this particular case was not trying to suggest anybody was cooking any books. He was just trying to track numbers. Maybe he thought you were cooking the books, but I don't think. I didn't look at it that way when they presented it to us.
Thanks. If I can go back to the one issue before we leave. I pulled up my original draft that I was working on with the attorneys related to the inviting the 3 municipal employees to observe tabulation. And we do tabulation on election night, and we then update the tabulation results throughout the election. For the first 2 weeks, it's every day, and then it trickles off to every other day. And so a plain reading of the code would mean that one of these 3 would have to be beholden to the election center and stop their work at City Hall and come to the election center up to 14 times through the election process. And so that was another fix that I was trying to deal with there was they come on election night, which is easy. And then beyond that, I think we're going to have to come up with some sort of schedule in order to get them here. One person being asked to leave City Hall and come drive 10 minutes down here to watch us do 30 seconds of work and then drive 10 minutes back to City Hall might not end up being practical every time. When we do have observers watching and...
Well, Madam Chair, I guess I'd recommend that if that's the problem, I wouldn't make it entirely permissive. I would say, at the beginning of each election and anytime there's any modification to software, you'll have this thing, for example, or, just again, going back to the last 2 elections, the issues were, people believed in what you were doing until somebody they didn't know came to, plug something into a computer to fix it. And
our staff plugged it into the computer.
I understand, but it was as I say, the observer process is an education process, okay? And it seems to me that I would not make it permissive. I'd keep it as it is and add something that says maybe at the beginning of an election, then anytime there may be a change in the tabulation process, there should be an observer, rather than make it totally permissive that you don't have to have it.
I guess I would add one comment, or one question would be, is 10 minutes of their time worth hours less of our time? If that 10 minutes is going to prevent an issue from even coming up or a complaint to be even made, it might be worth requiring them to come 14 times or a designee. I mean, you've got, 3 people or designee. I mean, they can designate whoever, but is by having them there, would that prevent, would that satisfy the complainants in a future election?
Sure, I hear what you guys are saying. I would say no, but I will remove this from the ordinance.
Okay, well, if the answer is no, then maybe it is an invited thing, but I don't know.
No, people, there's always almost half of folks who are not satisfied with close election results in a 2-person race. So I think that's a given. I think what you try to have is clear roles with clear safeguards, because at least in the time that I've been here, even though people have cast aspersions about, some election procedure or the other is trying to help one side or the other, I don't believe that's been the intent of either the drafters of the law or the executors of the law. And the clearer that you've got kind of sideboards and chain of custody roles and that sort of thing, the easier it is to have trust in the elections. That's all I'm saying. So I believe making this permissive could remove trust, and I appreciate your acceptance of the guidance you've heard today.
Thanks.
Any other comments, questions, or discussion?
Am I asking for a vote or anything from, no decision
I don't think you
on
need-
us for
no.
this?
I'm removing that one section, so.
Madam Chair, I move the proposed ordinance with the amendment of Section 2 that has been discussed with the removal of Section 2 as recommended by the commission.
All right, Commissioner Treadwell moved that we accept with the suggested changes. Is there a second?
Madam Chair, I will second.
All right, Commissioner Lehman seconds the motion. If all those that are in favor, say aye.
Aye.
Hearing no objection, the motion carries. All right, that finishes new business. And we are now down to member comments. Are there any commission member comments?
Madam Chair, I really appreciate the Matthew, you being here today and telling us what you've been working on from the assembly standpoint. And if there are major additions or suggestions that you come up with, if they can at least be electronically transmitted to us and we recess to the call of the chair, or you call up even a video conference, or that we do the workshop together. I just, I don't think that IT issue was, well, anyway, it was read 2 different ways, and you're going to look at that anyway, I hope. Happy to come to a workshop or to another meeting.
Thank you.
Any other commissioner comments, questions, or discussion?
I wasn't going to speak on this, but I think I'll pass it on to you, Matthew. I feel badly that what I think is very fine municipal employee from what I've heard. I don't know him personally. Kind of got thrown under the bus. And the municipality is the loser for losing a good employee. And sometimes things happen, you know, maybe somebody says something awkwardly or just slight misstatement, and much is made about it that was unnecessary. And from what I can see, this is one of those times where a very good employee probably would have been better served by counsel, you know, from perhaps people like yourself, rather than throwing them under the bus as a scapegoat. It's just, as I think about it, it's just, it was unnecessary. That's my opinion. So, anyway, that's my comment. And Jamie, you were an all-star. And thank you for the job you do.
Thank you.
All right, thank you. Any other commissioner comments, questions, or discussion? Hearing none, we will move on to public comment. Are there is there anyone in the audience who would like to participate in public comment? We have nobody in person, so is there anybody telephonically who would like to make any comments, have any questions, or offer any discussion?
There's two and they're both attorneys, so
Okay.
I don't think.
All right, hearing none, we will move on to adjournment. I would like to request a motion to adjourn the meeting.
So moved.
All right, we have a motion, and do we have a second?
Second.
And we have a second.
You can just ask
If-
if there's any objection.
Is there any objection to adjournment? Hearing none, we are adjourned on October 25th at 3:45 p.m.